was published long back. Your lordship knows that. November. That time her name was not appearing. He did not come. At a very belated stage, we can't. If there is anything done, it will be a topsy-turvy. Then again, we have to start the process from there. Then the verification, then the interview. It is impossible. Your lordships have dismissed one application. Just that is Urpita Pal's case. Kindly hand it over. On the same day this petition was filed, 8 December. 8 December.
Instead of percentage, she disclosed a percentile. I know. Any appeal against this? No.
No.
Not that. I wish somebody could have appealed. Because I don't know what to do. If the commission starts revisiting all the documents, then there may be several such candidates who are going to come over here. This is the reason the court doesn't want to interfere in these matters. You go through this judgment. This is against you.
Yes, my lord, judgment, but that judgment, I believe, my lord, although I get it here and now, I believe, my lord, although that is not binding precedent, but it's
Yes, binding, yes.
Thing is, you say this is a mistake and it is admitted that it is a mistake.
Obviously.
Why did you come so late? Had you come earlier, see, this was dismissed
on 8 December.
December. We are in February, 2 months.
I came, my lord, on that day, my lord. I came with the petition, my lord, filed on 8 December itself.
And see, it is coming up so late. Even had it been on that day also, the fate would have been dismissal. But then...
I just go with this judgment.
Go through it, come back. I'm not in your favor.
But the point is that, my lord, they give the edit option. Then, my lord, I have another submission is that, my lord, regarding the empowerment.
You have a bona fide case?
Yes,
then only I'll go into.
Case,
I do not see
46, my lord,
a bona fide on your part.
My lord, if I want to get benefit by giving the...
It is not only a matter of getting benefit. It is a matter of disclosing proper information. You can be held up or rather hauled up for not disclosing proper information.
My lord, with deepest of respect, my lord, then, my lord, School Service Commission ought to cancel each and every one online application who filled the wrong application, my lord, in respect of name, in respect of...
That is the reason for the benefit of the students.
Equal opportunity in public employment, that's my fundamental right. After last date of online application, if they altered others person details, my lord, from where they got that power? Rule says so. After last date of online application, they can't do nothing. But School Service Commission gave the opportunity in the favorite candidate. Obviously, my lord, the rule never empowered the School Service Commission because rule framed by the state government. Rule never, my lord, never give, my lord.
Leave, Millard, may I go? With your lordship's leave, Millard, can I leave, Millard?
Yes, you can leave.
Give the list.
The petitioner participated in second SLST for level class 11 and 12. Stuff. He incorporated incorrect marks obtained by him in his postgraduate examination. Come back. Stop. According to the petitioner, the incorporation of marks was an inadvertent error. Have you mentioned the cyber cafe and all these things over here?
No.
Then you didn't make out a case also. Acha. কি বললাম?
Next day, Malad,
Inadvertent error,
inadvertent.
and the petitioner will not gain anything out of the wrong incorporation of marks. On the other hand, he is losing 2 marks for account of such wrong recording. Stop. Paragraph, it has been submitted that on 3 occasions, the commission permitted the candidates to edit their details in the application form, but in none of the occasions was the option available for correcting error in the marks submitted by the candidate. Stop. Paragraph, it has been submitted that the that as the commission permitted editing of various details in the application form, comma, opportunity ought to have been granted to the candidates to rectify any error in any portion of the application form. Stop. Only, not only permitting editing of only selected fields is is in violation of Articles 14 and 16 of the Constitution. Stop. In support of the submission that minor errors can be rectified, can be permitted to be rectified, reliance has been placed on the order passed by the Honorable High Court of Madhya Pradesh, bench at Indore, in এটা টুকে নেবেন তো 15th March 2022. Stop. Learned advocate representing the commission opposes the prayer of the petitioner. Stop. The commission relies on the order passed by this bench on 8th December 2025 in WPA. Stop. Learned advocate for the petitioner seeks time to revert with further instruction. On such submission, how long? 2 weeks?
No,
Next week, 10th. Today is 3rd, next Tuesday, 10th. Yes. Yes, service taken on record. Yes.
This is Malad. With 200 rupees application, Malad. Yes, already is not accepted, but as well as the division bench, Malad, was the order in Shobnath Brahmanic matter.
And that has been modified in appeal. Did the petitioner
The Malad, page number thereafter, Malad, and this is the division.
A window was opened, directed to be opened.
Yes.
Did you? Yes.
We clarify that this measure is limited to persons who approach this court on this issue till 2:30 p.m. by way of filing of writ petition or appeal or otherwise. The next sentence is very important. Authorities are at liberty to deal with such the candidates who are not governed by this order in accordance. The Supreme Court says what is in accordance with the timetable. Let me look at them. But for what the authority? 2024 SCC online SCC 664 para 14.
Yes, para 14.
14 and 13. And I came out.
Yes.
Yeah, place.
Yes.
It is a well-settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. Thereafter, next paragraph, paragraph 15. Here is separate, that is quoted. By quoting, will settle principle. What the Full Service Commission did, put a cut-off date. Whosoever approach the court within a certain period of time, they only get benefit. So already is settled, same benefit to others.
But how long will this benefit be given?
Given to all.
How long?
Because of that, why? Because this is a mistake on the part of the Article 12 authority. They mentioned two also. One is old, sorry, part of the 3. So for that reason, my lord, the candidate were confused. The confusion created on the part of the Article 12 authority. Now they made mistake, and the candidate, my lord, they are suffering. Because the division bench judgment is not that you put a cut-off date. No, the division bench judgment says your decision in accordance with. But they took decision that whosoever comes to the court within a stipulated time, he will get benefit.
I see this. It appears that he filed the petition on 8.
8.
That is the record that say.
Hmm.
My lord, this window was open up to a particular time.
Hmm.
He had filed the petition, but he did not avail the window. It is impossible. Well, where is his pleading there? Then it is impossible. Everyone availed the window, my lord.
But then how will everyone get to know that there is a window open?
We have given a notice.
A notice was given.
Notice was given, my lord. Justice Boshak asked us to give a notice. This is 16th of December. Please see the notice, 16th December notice. He had put it up.
Such portal will remain open up to 6 p.m. on December 17, 2025. And up to 2:30 p.m. today, whoever filed the writ petition, portal was open. The writ petition was filed before.
Yes. So, my lord, this order was applicable for him.
He would have been covered by this order.
Yes. The authorities will open the portal at 6 p.m. today and keep the same open till 6 p.m. on. My instruction is it was open beyond.
The onus is on the candidate.
11 and 12. This is also 11 and 12 or what?
11.
This is 11, 12 candidate
Allow everyone.
or 9, 10.
Just give me.
This is a 9, 10 candidate. This is in respect of only 11 and 12.
No, the portal was.
Some are for 9, 10, some are for 11, 12. And for 9, 10, everybody was allowed. Next paragraph is there.
But the division bench's order.
Division bench's order is not restricted to Well, with respect, before the honorable division bench, if your lordship once again falls back to the order, my lord, start from page 1. Your lordship will be pleased to see, my lord, that the writ petition, the appeal.
Please come to
it
the
was not only
penultimate
one appeal.
penultimate portion.
Yes.
Paragraph 21. These directions are limited to the selection process of 11 and 12. Specifically mentioned. Come to paragraph number 17. We are concerned in this appeal with
But
regard
we have
to
allowed it for
candidates.
9-10 as
That
well.
is up to you, your magnanimity.
Because of this order, because of the nature of
Why
the order.
will the petitioner not be given the same benefit? Or,
It is contrary to the
or
division benches.
anybody
He had to avail it.
sailing on the same boat.
He had to avail it. Please see, our notice of 16. We have handed over.
Alert, may I use that?
1 minute, 1 minute.
This does not
16th and notice start.
Yes, it's here.
Alert, may I hand it over?
No, I have it. He has given.
No. 16.
Attached over here.
he was I want
This is to notify only.
I can see one paragraph. Similarly, following the spirit of the order, all candidates of classes 9 and 10
who have filed their applications form by paying the
are also given a final opportunity
are
to read
also
it.
given up to 8:30 p.m. on 17/12.
Hmm.
And this was uploaded in our website. In terms of this, there was no further complaint.
You never know, matters are coming.
There are no further complaints. Your lordship has also not come across such a complaint.
As indicated
Then
in
this
the...
window has to be kept open for eternity.
No. Who disentitled can...
when the notice was uploaded.
We come to your lordship's court. We carry an appeal before the honorable division bench. The honorable division bench will not request the learned senior counsel representing the commission that if something can be done. On instructions, it was done. And in terms of the concession of the learned senior as well as the commission opened the window for a particular period, published a notice in its usual way.
All right, I will open one window from him. He'll get it.
Kindly do not.
He'll approach the division bench.
Kindly do not.
He'll approach the division bench. Get it done.
Malad,
Achha.
at this that malad, this Onamika malad,
Hmm.
get benefit of in respect not in respect of 9-10. That's my instruction.
Anamika got... Did she
These are all statements from the bar. Kindly do not.
check up?
We do not. How can I check up just now?
If you want, I can adjourn it. Check it up. And she applied at the same time.
Yes. And both the
So it is impossible. It is impossible.
Check up. He may be wrong. Check up.
give the benefit.
Check up. If it is not there, I open my mind that I'll refer the matter to the... Not refer. I'll grant leave to the petitioner to approach the division bench and get it done, because you acted in terms of the division bench's order. You acted in terms of the division bench's order. Now, this court cannot direct modification or anything of the division bench's order. The petitioner will go and get opt-in order from there.
এটা রিপিটিশনে কি করে অ্যানেক্স থাকবে
Annex নেই তো
অ্যানেক্স থাকলে আমি কি করে বলবো
Where is it mentioned that she got the benefit in 9-10? It could not be, because after filing. True.
what I was respectfully submitting. Lordship may pass. Let him first use a supplementary affidavit disclosing exact position factually so that we can come back.
All right. The petitioner participated in the second SLST in respect of classes 9, 10 and 11, 12. Stop. She claims to be a member of the reserved category and had applied by submitting fees meant for reserved categories. Stop. Her allegation is that she has been treated as a general category candidate as she failed to update/edit her caste details in terms of the opportunities granted by the Commission. Stop. Learned advocate for the petitioner relies on the judgment delivered by this bench on 27th November 2025 in WPA. এটা লিখে নেবেন তো, সোমনাথ প্রামাণিক and others. ঠিক আছে? The judgment passed by the Honorable Division Bench in the appeal against the said order on 16th December 2025 in MAT 2115 of 2025 has also been placed before the court. Stop. Learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Lieutenant Colonel Suprita Chandel versus Union of India and others, reported in 2024 SCC Online SC 3664, paragraphs 14 and 15, wherein the Honorable Supreme Court reiterated the settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his/her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. Stop. The judgment in the matter of Amrit Lal Berry versus Collector of Central Excise, New Delhi, reported in 1975 4 SCC 714, has been relied upon. In support of such principle. Stop. The আচ্ছা, অমৃতলাল বেরি বললাম তো, তার সঙ্গে K.I. Shepherd 714 and K.I. Shepherd versus Union of India, reported in 1987 4 SCC 431, have been relied upon. দুটোই এখানে আছে, please check. ঠিক আছে? Stop. Learned advocate representing the petitioner submits that the petitioner tried to update her reservation details within the time limit fixed by the Honorable Division Bench.
Division may not file stipulated any time. Division may stipulated the time for those candidates who approach that.
No, such portal will remain open up to 6 p.m. on December 17. This time is also there. Acha. কি বললাম? Her division bench and in accordance with the public notice published by the Commission on 16th December 2025. But even though the portal permitted the petitioner to update her category details in respect of classes 11 and 12, but her category details in respect of classes 9 and 10 were not permitted to be updated. It appears that the aforesaid fact is not mentioned in the writ petition. Stop. Leave is granted to the petitioner to file supplementary affidavit disclosing such fact. Such supplementary affidavit may be prepared and circulated by how soon? This Friday? Or you want the weekend? See, 10th of November. Release the matter on 10th of February. Release the matter on 17th February. Learned advocate representing the commission shall take necessary instruction in the meantime.
Because of that, why this fact is not narrated in the recruitment? Because this notice given on 15.
Yes, I have followed it.
My lord, I appear on your statement.
Please enter your appearance.
My lord, I
Take to Rekhi Vishnu, we will.
কোনটা পাননি খুঁজে
We have to take instruction on her application.
আন্দাজে করে দিয়েছি মানে এটা ফেরত দিয়ে দিন ওনাকে
Lordship, we have to take instruction on her application status.
তাহলে আপনি আন্দাজে কি করে করলেন something.
Look, we have to take instruction on her application status.
Yes. Whether the petitioner says that the her 11-12 has been updated, but 9-10 has not been updated.
9-10, everybody was permitted to update 9-10 for 24 hours.
Well, just check up. It won't take much time for you to get it. Yes, next. Yes.
On behalf of the Central School Service Commission for fresh recruitment for the assistant teachers of the class 9 to 10, 11 to 12. There is the history of this.
No, I do not want to know the history now. You tell me what is your prayer.
My prayer is very simple. I have challenged the notification.
The notification is of May. You challenge it in December. In the meantime, the selection process commenced and results were also declared. How will your writ petition and why will your writ petition be entertained?
My lord, this is the predicament I am facing, my lord.
You have to make submission.
My lord, the first and foremost, my lord, kindly comes to the order of the Honorable Supreme Court, my lord.
Yes.
It is on 3rd of April 2025.
Yes.
And the judgment was passed in 17th of April 2025. My lord,
yes.
Comes to the operating part.
Page?
My lord, page 125, your lordship.
125.
Pardon me, lordship, it won't be 125, it will be
112.
12. Thank you. My lord, the paragraph number 45, your lordship.
Yes.
The last question relates to the relief, whether it requires any modification. We find no valid ground to reason to interfere with the direction of the Honorable Court that the services of tainted candidate were appointed must be terminated and we should not require any refund and any salaries. My lord, they said the relevance in this when for the candidates not specifically found to be tainted.
Are you a tainted candidate?
No, my lord.
All right, then what do you want?
My lord, thereafter, pursuant to this order, this notification has been published.
Yes.
The only predicament being this, I have been approaching this Honorable Court after quite a long period. My lord, I am granting a relief to give me a chance to make a representation before this.
For what purpose? Representation for what? Did you apply?
Yes, your lordship, I applied.
You applied in terms of the notification. You are unsuccessful.
No, my lord, it is kept in abeyance, my lord.
What do you mean to say abeyance?
My lord, this is my lord kindly gives me a day's time because the learned advocate on record has briefed me just now. I have been appearing before.
All right, take time.
When? On 9th.
Next week?
9th.
9th?
Yes.
All right, 9th. Next one also same?
Yes, lord.
9th? 9th.
File you.
Take back your affidavit of service.
It's still same.
Same.
Oh, but Lumana to
Yes.
okay.
এই সার্ভিসটা ফেরত দিয়ে দেবেন
Fine. Oh, lovely.
This is that hearing, that 10 marks hearing, which was continuing.
Your Lordship, we have to make our submission. Learned Advocate General is on his way. He's coming.
Why don't you start?
Your Lordship, I will just give a brief background on what points we'll make our submission. Then Learned Advocate General. He's here. Your Lordship, oh, he's here.
Say. Even say for 2 minutes.
And to start. Yes.
I'm saying go to.
Wait, I will declare you.
I'm sorry, my lord.
No, it's all right. But these are opportunities for the juniors which they
Yes.
should grab.
Yes,
And
definitely.
wait till the senior comes.
But in fact, these opportunities are getting rare. It's
The
not
seniors are jobless, you say?
no.
Then
I'm saying from the court's perspective, not every court is kind enough to give that opportunity.
that is different.
But that difference is
I don't comment
no,
on this.
Lordship need not. Neither I am commenting. Lordship need not. I don't want. But I'm saying these opportunities are actually, which we have heard stories about it from our seniors, and we also say that is getting very scarce.
No, my lord, your lordship has been pleased to, my lord, hear several learned counsels in the matter.
Hmm.
So on facts, I don't think, my lord, I need to, my lord, dilate any further.
Hmm.
But I'll try to be as concise as possible. But my first submission would be in the form of exclusion. Exclusion in the sense, number one, my lord, no argument has been advanced before my lord that prior teaching experience is not required. Considering the nature of the job, considering the post prior teaching experience is uncalled for, no submission has been made to this effect. The corollary is prior teaching experience can be one of the qualification.
Yes. Hmm.
Number two is no argument has been made that owing to the prescription of prior teaching experience, the inexperience, if I may dissect them into two classes,
Hmm.
the inexperience will be completely eliminated. No argument has been made. The argument is that if you provide for prior teaching experience, then the selection would be one-sided. Milord, I remember, subject to correction by your lordship, Milord, because I was always not present before my lord. Mr. Bikash Ranjan Bhattacharya submitted that except this prior teaching experience, other things are level playing field.
Therefore, my second point of elimination is that no argument made that the inexperienced candidates would be completely eliminated. The argument is that it would be one-sided in favor of the experienced one. But these are the two fundamental exclusion that I intend to make. The third, which is a somewhat in the nature of an exclusion, is that why challenge the 2025 rules? Because a line of argument at the beginning was there that Supreme Court meant that 2016 or the fresh selection should be as per the 2016 rules. To that, my lord, this is again made in the form of an exclusion also, that take, or assuming for argument's sake, on hypothetical basis, if I assume that the 2025 rules is declared to be invalid by this court, but we cannot go back to 2016 rules because there was a 2019 rules in between. Or in other words, the principle which has been laid down by your lordships are that if a rule is declared invalid, that would not revive the superseded rule. Because the superseded rule or the repeal or the rule which has been repealed or the law which has been repealed, on its repeal, it has gone out of the statute book, it has gone out of the rule book as if it never existed. So, my lord, blood cannot be infused to a rule which has ceased to exist by dint of a legislative action. Therefore, we cannot go back to the 2016 rules.
Yes.
Therefore, what we are left with fundamentally are on two aspects. Number one is, whether weightage can be granted in a selection process. Weightage can be in various forms. Weightage can be, say, age form, weightage can be in marks form, weightage can be in experience form. So fundamentally, the first question which I need to address, your lordship, is whether weightage can be given, in a selection process, number one. And number two is whether, the selector can choose between the experienced and the inexperienced. But these are, the two fundamental arguments which, I will be advancing before my lord, in support of the rule which has been framed, in exercise of powers, under the subordinate legislation which has been framed. Now, first, I would like to, confine the mode of challenge to subordinate legislation. Where your lordships have held that the subordinate legislations do not enjoy the same immunity as that of the parent legislation, or in the sense that the presumption of validity at the very beginning, as applicable in case of a challenge to a parent statute is not applicable in its full vigor when a subordinate legislation is challenged in court. Therefore, my lord, the Supreme Court has culled out 4 or 5 grounds on which, my lord, the subordinate legislation can be challenged. Those are, first is legislative incompetence, where no one, in my very respectful submission, has said that there is a legislative incompetence. The second is fundamental right violation, which I'll address, Your Lordship. The third is infraction of any other provisions of the Constitution or other constitutional rights. Second and third may require, my lord, Your Lordship's attention. The fourth is not conforming to the authority granted by the primary legislation. Not conforming to the authority granted by the primary legislation. I don't think, my lord, Your Lordship has been addressed on that also. The fifth is repugnant to the parent statute. I don't think that has also been addressed, Your Lordship. The sixth is, which is somewhat ticklish, is arbitrariness. Now, why I use the expression ticklish? Because arbitrariness is not as wide in the context of a subordinate legislation challenge as that of ordinary arbitrariness in other fields. Arbitrariness has been confined to the extent that you have to look into the arbitrariness from the angle that the primary legislation did not confer power to provide for such a provision. That is arbitrariness in the context of challenge to a subordinate legislation. It is not that this is arbitrary because you are comparing between black and white. You have to say that the legislation did not confer any power on you to provide for a comparison between black and white. So this arbitrariness, or the sixth facet, is not as wide as the arbitrariness that we understand. Say, for example, in the commercial field, tenders and all that. So, these are, the four. The 6 fundamental grounds, on which, subordinate legislations are challenged. I think, I have to address your lordships on the second, third, and sixth aspect. First is, your lordship, I will not, multiply decisions on each topic. I'll be as misered as possible. First is, না 6-4 আছে পি কৃষ্ণমূর্তি আগের দিন লাস্ট যেটা বলেছিলাম আচ্ছা 79(3) দে তাহলে Milord, only one request, Milord. I'll be very unfair to the court. But I've got a matter fixed at 2 p.m. It's a continuing matter.
First half.
First half. এটা কোনটা 79 But the first judgment, Milord, in the sequence is 2006 is reported in 1979 volume 3 Supreme Court cases 229. But here, Milord, a regulation, Milord, under the Electricity Act was under challenge. Well, one paragraph from this judgment, which is paragraph 41. The grounds of challenging the validity of subordinate legislation are well known. The challenge may be on the ground that the power to make the law could not have been exercised in the circumstances which were prevailing at the time when it was made, or that a condition precedent to the making of the legislation did not exist, or that the authority which made the order was not competent to do so, or that the order was not made according to the procedure prescribed by law, or that its provisions were outside the scope of the enabling power in the Parent Act, or were otherwise violative of its provisions or of any other existing statute. As it happens, none of these grounds are so and so. Therefore, Millard, in 1979, Millard, the Supreme Court was more concerned about the or confining the challenge to a subordinate legislation more on comparison with the parent legislation. And the situational needs. Now in 2006, Millard, Supreme Court expands the scope of challenge. Please have a look to Millard, this judgment, which is P. Krishnamurthy, which is consistently followed. This P. Krishnamurthy, reported in 2006, volume 4, Supreme Court cases 517. Please come to Millard, paragraph 15, 1-5. There is a presumption in favor of constitutionality or validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds. 1. A. Lack of legislative competence to make the subordinate legislation. B. Violation of fundamental rights guaranteed under the Constitution of India. C. Violation of any provisions of the Constitution of India. D. Failure to conform to the statute under which it is made or exceeding the limits of the authority conferred by the Enabling Act. E. Repugnancy to the laws of the land that is in any enactment. And F. Manifest arbitrariness, unreasonableness to the extent where the court might well say that the legislature never intended to give authority to make such rules. Now, this arbitrariness or unreasonableness is confined to only this part. Because arguments are often made that this is arbitrary, this is arbitrary, this is arbitrary. Article 14 is Millard brought in. But in a challenge to a subordinate legislation, Millard, the expressions arbitrariness or unreasonableness does not have its full play. It is connected to what the legislature intended. If the legislature did not intend to provide for prior teaching experience, then of course, Millard, it can be. But Millard, we often have seen, Millard, that prior teaching experience or any other weightage has succeeded in court, Millard. There are innumerable judgments, few of which, Millard, I'll place before my Lord. Then, Millard, this P. Krishnamurthy is consistently followed, but I'll show one judgment, two judgments more only, which is 2000. Next one is 2016, volume 7, Supreme Court cases 703. Please note down the paragraph number only. It again quotes P. Krishnamurthy. Para 34. Nothing much on this. Now, the last judgment in this series is 2022 SCC Online SC 444 Dental Council. Which is also the regular citation is 2022 Volume 6 SCC 65. দিয়ে দে Please take me note paragraphs 24 onwards. Here, Millard, the subordinate legislation was quashed. The division bench of the High Court vide judgment has allowed the writ petition and quashed the impugn notification on 3 grounds. 24.1, that it is violative of Article 19(1)(g). 24.2, that is beyond the scope of the powers of the Council to make delegated legislation as provided under the section. 24.3, that it is violative of Article 14 inasmuch as the dental colleges established prior to the impugn notification would be permitted to run without attachment with medical colleges, whereas the dental colleges established after the impugn notification will be compelled to have such an attachment with the medical colleges. We find that the learned judges of the division bench have erred on all counts. It will be relevant to refer to the following observations of the court in Indian Express. A piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by the statute passed by a competent legislature. Subordinate legislation may be questioned on any of the grounds on which plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the statute under which it is made. It may further be questioned on the ground that it is contrary to some other statute. That is because the subordinate legislation must yield to the plenary legislation. Power চলে যাচ্ছে 10% plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the, I'm sorry, Millard, I've missed 1 or 2 lines. It may further be questioned on the ground that it is contrary to some other statute, though it may also be questioned on the ground of unreasonableness. Such unreasonableness should not be in the sense of not being reasonable, but should be in the sense that it is manifestly arbitrary. This is the qualified application. It has further been held by this court in the said case that for challenging the subordinate legislation on the ground of arbitrariness, it can only be done when it is found that it is not in conformity with the statute or that it offends Article 14 of the Constitution. It has further been held that it cannot be done merely on the ground that it is not reasonable or that it has not taken into account relevant circumstances which the court considers relevant. Then, Millard, on the experts field, please take, Millard. Then, Millard, this Krishnamurti is again considered at para 30. Now, please come to, Millard, paragraph 41 onwards, where, Millard, the requirement of the authority is looked into. This court, in unequivocal terms, has held that it would be wholly wrong for the court to substitute its own opinion for that of the legislature or its delegate as to what principle or policy would best serve the objects and purposes of the Act. It has been held that it is not permissible for the court to sit in judgment over the wisdom and effectiveness or otherwise of the policy laid down by the regulation making body and declare the regulation to be ultra vires merely on the ground that in the view of the court the impugned provisions will not help to serve the object and purpose of the Act. We find that the observations quoted herein above of the division bench of the High Court are totally contrary to the view expressed by this court in so and so. The division bench of the High Court has erred in substituting its wisdom with that of the rule-making body, which is an expert body. In this respect, it will be apposite to refer to the observations of this court in so and so. After considering various judgments on the issue, the court observed, the courts are neither equipped nor have the academic or technical background to substitute themselves in place of statutory, professional, technical bodies and take decisions in academic matters involving standards and quality of technical education. If the courts starts entertaining petitions from individual institutions or students to permit courses of their choice, either for their convenience or to alleviate hardship or to provide better opportunities, or because they think that one course is equal to another without realizing the repercussions on the field of technical education in general, it will lead to chaos in education and deterioration in the standards of education. The role of statutory expert bodies on education and role of courts are well defined by a simple rule. If it is a question of educational policy or an issue involving academic matter, the courts keep their hands off. We are therefore of the considered view that it was not permissible for the division bench of the High Court to enter into an area of experts and hold that the unamended provisions ought to have been preferred over the amended provisions. But somewhat similar submissions are being made. That 2016 rule did not permit or did not provide for prior teaching experience. Then the last paragraph is paragraph 47. I can skip over 47, not that important. Therefore, it's ultimately the requirement of the competent authority or the expert body that has to be given credence. But there can always be a better formula. There can always be a more comprehensive, more compatible procedure or a provision. But that cannot be a ground for entertaining a challenge to a subordinate legislation. So, this is my first limb of submission, that what is the scope of challenge to a subordinate legislation. Second, third, and sixth facets on which I need to address your lordship, because on the first, fourth, and fifth no arguments have been admittedly advanced. But there is a very well written special bench judgment of the Telangana High Court, where for contractual employees, out of 100 marks, 45 marks or 45% marks was awarded to those who are coming from or who had a contractual service experience, whereas the other persons, or they call it open market candidates, they were deprived of this 45% marks out of 100. Therefore, obviously, it fell for challenge. Initially, it did not succeed. Then, since it was Andhra Pradesh, therefore, after the state got bifurcated, the second batch of writ petitions filed, where the Telangana said that we are not going to follow Andhra Pradesh. Then a third batch of writ petition filed that why not follow Andhra Pradesh rules. Then the matter was referred to the larger bench. In this scenario, the larger bench of the Telangana High Court was considering, but this is a sort of a digest, this judgment. Your lordship may kindly consider this. This is 2020 SCC Online, Telangana 1073. A longish judgment, but it is considering several judgments of the Supreme Court on several points. May I place, hurriedly, a few paragraphs on facts? Please take para 1. On so and so, a series of writ petitions challenging the grant of, comma, or non-grant of weightage marks to contract employees by the state government or by different power utility companies. Now, skipping the rest, please take paragraph number 2. On so and so corporation issued notification for filling up vacancies for the post of sub-engineer, lineman and junior lineman. The notifications prescribed by the selection procedure, that is, out of 100 marks, 45 marks were earmarked for service rendered on contractual basis, thereby leaving only 55 marks for written examination. The grant of maximum of 45 marks as weightage marks depended on the length of service rendered, that is, 2.5 marks would be given for every half year of service as contract worker in the organization. The decision to grant weightage marks was based on a settlement arrived between the managements and such. However, the open market candidates challenged the apportionment of 45 marks as weightage marks to the service rendered on contract basis before this court and in a batch of writ petitions. The petitioners therein contended that no such weightage marks could be given to a group of candidates, for it would make the selection totally one-sided. Hence, the grant of weightage marks was arbitrary and discriminatory. However, by the order of so and so, the learned single judge upheld the grant of weightage marks, etc., etc. With the rest of the facts, I've given you, Lordship, brief background of the facts. I will not trouble you, Your Lordship, with those. Now, it was referred to the larger bench because of certain reasons. Now, please take, paragraph number 20.
Yes.
In the above background, the full bench is required to answer the following issues. Issue number 1, we are not concerned. Please take issue number 2. As part of the selection process for direct recruitment, whether the employer has the power to apportion marks towards service rendered by a person on temporary basis or not. If yes, whether such power is an enabling power which cannot be claimed as of a right by the employee. To what extent marks for contract service on outsourcing basis can be prescribed out of total marks for the selection. Then, the cases are categorized. Please take para 21. Under 21, capital A, Division 1, recruitment in government service. Division B, Division 2 is recruitment to government utility. Under that, category 1. Challenge to the constitutional validity of the Rule 31 of the so-and-so rules, which vests power in the governor to, oh no, this is relaxation. I skip over this. Please come to category B at the next page. Pertain to challenge the validity of so-and-so issued by so-and-so, by which Rule 9 of so-and-so was relaxed and weightage of marks to contract services was prescribed. Then category 3 is denial of weightage. Then, these are all categories defined. I will not trouble your Lordship with those. Now, please come to paragraph number 55. First, the issue is answered. Then, the reasons. Reasons follow the answer. The answer is para 55. The issue is answered as under. Please take Roman 4 under that, or Roman 3 also. The rule is not unguided or unbridled. Enough safeguards have been provided against arbitrary exercise of power of relaxation. 4. Employees working on contract basis are clearly an identifiable group. Thus, they are a class by themselves. We're pausing here for a moment. My submission would be that the persons with teaching experience are a classified or clearly identifiable group. This would be my submission. Yes, in substantive post. And the power to relax so and so, we are not concerned about relaxation. Please skip over 5, then 6. Relaxation of Rule 9B of so and so paves way to compute the contract service for weightage in the process of direct recruitment. That is in the facts of that case. Now, thereafter, my lord, your lordship may kindly take para 56 onwards. Well, I'll read a few paragraphs, my lord, from here. Before we examine and decide the issues framed herein above, it would be apposite to first delineate the general aspect of selection process, the legal difficulties which arise in the process, and also to deal with the case law on different aspects of selection process. For this discussion would be useful for the final decision about the issues framed and mentioned above. There are certain prerequisites for employment in the state service or in service under the state entities. The eligibility criteria need to be prescribed. Regular recruitment should be made by following the procedure prescribed by the service rules, regulations, bylaws, policy, decisions, circular instructions governing the service. Before commencing the recruitment process, wide publicity indicating the eligibility criteria and procedure for selection need to be given. The selection has to be conducted in a transparent manner. The selection must be in strict compliance of Article 14(16) of the Constitution. Eligibility criteria include educational, professional, technical qualification, experience, age, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both, prescribing minimum pass mark in the written examination and or prescribing minimum pass mark or oral examination, shortlisting of candidates for further selection by holding screening tests, prescribing preference based on higher educational qualification, age, experience, etc. Employer can prescribe tests to assess the skill in a particular discipline, such as typing, shorthand, etc. Thus, it is for the employer to custom tailor the eligibility criteria and or selection procedure as per his requirement. The employer is the best person to assess the qualification required to hold a post and method of selection. Every person who possesses, I can skip over for 59, 60, 61. Please take 62. Recruitment to public employment is a perennial source of litigation. It covers a vast range of issues, from appointing on temporary basis to continuing temporary employment for long years, from not resorting to regular recruitment to reservation to social groups, from eligibility criteria to method of selection to illegalities in the selection process, etc. Broadly, there are 4 aspects to employment in public service. Scope of power of the employer to regularize the services of persons employed on daily wage basis, normal master role, employed on consolidated wages, employed on contract basis, employed on outsourcing basis, etc. For brevity, hereinafter broadly classified as temporary employees. 2, assigning preference. We are here. Assigning preference to a class of person in the selection process for employment. Prescribing a procedure for selection for direct recruitment. Scope of judicial review in matters concerning selection and weightage to temporary service. Then, my lord, please come to para number 76 or 74. But in 74, the heading is assigning preference to a class of persons in the selection process for employment, that is II, and III is prescribing procedure. Employment in the state service, where I skip over my lord 75, not required. Please take 76. 2 fundamental aspects which govern public employment are prescribing eligibility criteria to a post and the transparent procedure of selection. Eligibility criteria include educational qualification, age, experience, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both. The employer may prescribe minimum pass mark in the written examination and or prescribe minimum pass mark in the oral examination. The employer may resort to shortlisting of candidates for further selection. By holding screening tests, the employer may also prescribe preference based on higher education qualification, age, experience. So this is accepted. Weightage on experience, amongst others, are accepted, etc. Assigning weightage to service rendered on temporary basis and weightage to seniority in acquiring educational qualification also come under the procedure of selection. Employer may prescribe tests to assess the skill in a particular discipline, such as typing, etc. Thus, it is for the employer to custom tailor the eligibility criteria and/or selection procedure as per his or her requirement. The employer is the best person to assess qualification required to hold the post and the method of selection. Therefore, weightage for experience is sanctioned by law. Then we can skip over Miller 2 paragraphs. Or I can read Miller the last sentence of para 78. This is the right, Miller, which Miller an incumbent applicant has. Please check the last sentence is paragraph 78. In fact, the right is of equal opportunity to compete a right of consideration, but certainly not of appointment. Well known that I need not, Miller, trouble you with all that. Now please take Roman 4, Miller, after para 78. Scope of judicial review in matters concerning selection and weightage. Judicial review of administrative action is the core of our constitutional scheme and the rule of law. It is all pervading and encompasses all aspects of executive actions where rights of individuals are affected. However, scope of judicial review in matters touching recruitment to public employment is in a narrow compass. Judicial review on such aspects is confined to whether any malafide stroke arbitrary decision was taken to prescribe a particular qualification only to favor a particular person, not a class. Or persons, and or such qualification do not at all required to hold the concerned post, but is prescribed in order to eliminate a person or persons. That is why, Miller, I wanted to exclude what was not argued. But the argument is not that this prior teaching experience is not required for the post. And this is what Miller, the full bench, says, that the judicial review is available inter alia for prescribing a qualification which is not required for the post, but is prescribed in order to eliminate a person. No argument has been made that these, according to me, as I have put it in two compartments, that the inexperienced gets completely eliminated. And if there are illegalities in the selection process, vitiating the selection, this has not happened as yet. As long as the eligibility criteria and the procedure for selection meets the mandate of Article 1416 and 309 of the Constitution, and no illegalities are pointed out in the selection process, the scope of judicial review on the qualification prescribed to a post and the procedure for selection is a limited one. Now, the Supreme Court in para 80, I would like to keep it for my future references, is a digest of the Supreme Court judgments. From the precedent decisions of the Honorable Supreme Court on the scope of judicial review in matters of prescribing eligibility criteria, selection procedure, and the right of a candidate seeking public employment, the following principles can be called out. Article 14 and 16 or 16 of the Constitution neither exclude the laying down of selective tests nor preclude the government from laying down qualification for the post in question. Such qualifications need not be only technical, but they can also be general qualification relating to the suitability of the candidates for the public service as such. State of Mysore, so suitability of the candidate for the service. I consider an experienced teacher to be more suitable than that of a inexperienced one. Then 2, the court should not usurp the function of determining the appropriate method of selection. So much argument has been made. When should the marks be given for prior teaching experience? At which stage? 2K and 2L. That is why this is important. Court should not usurp the function of determining the appropriate method of selection and the relative weight to be attached to the various tests, even in the case of proven or obvious oblique motive. What would be amounting, that would be amounting to rewriting the rules. The court do not undertake such an exercise. Leeladhar so and so. Matters relating to creation and abolition of post, formation and restructuring of cadres, prescribing the source, mode of recruitment and qualification, prescribing additional and desirable qualification, including grant of preference, criteria of selection fall within the exclusive domain of the employer. The court has no role either in determining the methodology of recruitment or in laying down the criteria of selection. It is the employer who is best suited to decide the requirements that a candidate must possess according to the needs of the employer and the nature of the work. In the garb of judicial review, a court cannot sit in the chair of the appointing authority and decide what is best for the employer. Moreover, the court cannot sit in appeal over the judgment of the employer and ordain that a particular post be filled up in a particular manner. This is what the petitioners have invited the court to undertake. That the court must direct at what stage should the prior experience marks be awarded, or inviting the court to lay down the manner in which it should be done. The court cannot lay down the conditions of eligibility if the language of the advertisement and the rules are clear. The court cannot sit in judgment over the same. In such matters, the power of judicial review can be exercised only if it is shown that the action of the employer is contrary to any constitutional or statutory provision, or is patently arbitrary, or is vitiated due to malafide. It is also not open to the court to make comparative evaluation of the merit of the candidates. That stage has not come. Court cannot suggest the manner in which the employer should structure or restructure the cadre. We are not concerned about that. Next, 4. Since the administrative authorities have experience in administration, the court must respect this. Thus, the court should not interfere readily with administrative decisions. The court should not ordinarily interfere with policy decisions unless there is a clear violation of some constitutional or statutory provision or the statute. There should be judicial restraint in administrative decisions. An enabling provision postulates a discretion which may or may not be exercised. The court cannot find fault in exercising an enabling power in a particular manner. Where the executive action of the state is challenged, the court will tread with caution and not overstep its limit. The interference by the court is warranted only when there are oblique motives or there is miscarriage of justice. The recruitment notification merely amounts to an invitation to the qualified candidates to apply for recruitment. On their selection, they do not acquire indefeasible right to the post, even if all the vacancies notified are not filled up. In service jurisprudence, constitutional court should balance the equality principle with the principle of classification. Dependent on the nexus for making the classification, this aspect is best left to the wisdom of the administrative authorities. Pausing here for a moment, as I have initially submitted 2 or 3 minutes, I have submitted sometimes back, that this is not a pure service matter simpliciter. My lord, in the context of deciding the validity of the rules, has to take into consideration, I won't say has to, needs to take into consideration what is the purpose. The purpose inter alia is to also provide for better education for whom these persons would be, or the intending candidates would be selected. Therefore, that has to be kept into mind. That is it a simple comparison between 5 candidates who have offered their candidature, or is it a consideration amongst 5 candidates who can serve the best or who can provide better quality service for those for whom they are intended to be appointed?
The nexus to be.
Yes, this is the nexus. Therefore, the nexus for making the classification is also very important. Apart from classifying between group A and group B, the nexus is that according to the legislature, persons with better qualification or persons in group A can serve better, persons in group A can provide quality service or education, whatever. Therefore, this is the nexus. Apart from whether weightage preference can be granted or not, the underlying important aspect of the matter is the nexus that these persons or persons with this qualification can serve better or provide better services. Because now we need to also keep in mind that Article 21A has come. Then, Millard, I was in 8. 9. In the mode of selection, if the mode of selection is not prescribed by the rules, and there is no other impediment in law, it is permissible for the competent authority to lay down the norms for selection, such as holding test, minimum benchmark, and written test, as well as viva voce. Paragraph so and so. 10. If classification is otherwise legal, valid, and reasonable, it is not prohibited by Article 14. Because so much of the arguments were made on 14 and 16. I say, Millard, this classification is otherwise valid, has a nexus, weightage is permitted in law, preference is permitted in law, and therefore, Millard, the legislation or the subordinate legislation cannot be faulted. Then, Millard, para 81. Para 81, Millard, is the conspectus of whatever was discussed above. From the above precedential case law on all the 4 aspects, it is thus safe to conclude that we are not concerned about A, please take B. In the process of direct recruitment, it is open to the employer to permit temporary employees and not governed by the directions in para 53 of Uma Devi to compete in regular recruitment by relaxing age regulation and by assigning weightage to such service. Then 3, C, it is for the employer to prescribe procedure of selection for direct recruitment to public employment. While D, while prescribing procedure for selection, it is permissible for the employer to apportion marks for temporary service, seniority, so and so. This E, the scope of judicial review in matters of prescribing qualification, procedure of selection, and method of selection is very limited. The writ court cannot act as a court of appeal and cannot determine what qualifications can be prescribed to hold a post. It cannot prescribe the procedure of selection to make regular recruitment. Only when there is a patent illegality in the selection process would the writ court interfere. But we are not, the challenge is not to the selection procedure or process. The challenge is, number one, prescription of prior teaching experience, and when should it be given?
No, the other challenge is whether the prior teaching experience marks can be allotted only to the state government teachers. There are central government teachers, there are private school teachers, aided, non-aided, lots.
But
The classification.
That classification, Supreme Court has upheld. That you can discriminate.
We'll come to that later on.
Which is called, as per the Supreme Court's words, valid discrimination. But here, Millard, the Supreme Court, Millard, distinguishes between an invalid discrimination and a valid discrimination. I'll come to those. There's a Rajasthan
judgment has been placed.
Yes.
All right, we'll see that.
Then paragraph number 82, guided by the above principles, so and so. Then I need not trouble your lordship with the middle paragraph. Now please come to para 99. This is a classic case where below 10 marks extra for a particular college. Kindly see. In Sanjay so and so, challenge was made to clause 3 of chapter so and so. Selection was based on written examination. In the process of determination of merit for selection to post-graduation courses, 10 marks were assigned to students who had graduated from Rohtak Medical College. Therefore, one particular college gets precedence. It was urged that due to assignment often additional marks, the graduates of Rohtak Medical College were pushed up in the merit list. Though this decision concerns admission to postgraduate medical courses, but the basis of challenge is the same as urged in the present set of writ petitions, namely challenge to the grant of weightage mark. However, the apex court repelled the contention of discrimination and of offending Article 14 of the Constitution of India, para such and such. So even in a case where out of 10,000 colleges, students of one particular college gets an advantage, will it upheld. Then please take me to the next one, that is para 100. Consistently, the Honorable Supreme Court has upheld the power, but if your lordship requires me, I can place these judgments, but
no, it's not required.
That will make it very long. Consistently, the Honorable Supreme Court has upheld the power of the employer to assign weightage to temporary service rendered by a person and to grant age relaxation while making regular recruitment. Then please come to paragraph 113. Conclusions on this issue, 113. But please take the last 3 lines of that page. If employer requires. If employer requires a cook, he may prescribe cooking experience more than educational qualification. For a particular post, the employer may give more weightage to experience than to higher qualification, higher educational qualification. For certain posts, say class 4 posts, employer may prohibit persons with higher qualification. Thus, depending on the requirement of a job, appropriate qualification eligibility criteria may be prescribed. It is the prerogative of the employer. The judicial review cannot be stretched to oversee what qualification, eligibility criteria, and the mode of selection should be prescribed by the employer. In the present cases, admittedly, there is a large pool of employees having basic qualification who have undergone processes of selection, have rendered considerable service, and have gained experience in the core aspects of the job for which recruitment process is being taken up. Experience gained by them is certainly useful for the employer. The employer may thus prefer a person with experience over a raw person. Therefore, preferring a person with experience on the same job neither amounts to bias nor to arbitrary exercise of power. It is a classification based on intelligible criteria, that is experience on the same job versus inexperience. So it's a choice between experience and inexperience. The purpose, the ultimate purpose. But here, of course, the Supreme Court, the Telangana High Court was not considering the purpose or the other aspect. Then please take me, Lord, weightage, 118. Thus, grant of weightage marks is legally permissible. Hence, the arguments raised by the learned counsel against the grant of weightage marks are clearly untenable, hence unacceptable. Issue number 3. Whether such power is an enabling power which cannot be sought as a right. Ancillary to these issues are 2 more questions. A. whether employer, the state or its instrumentality is under obligation to extend the scheme of weightage to temporary service rendered outside its employment or not, and B, whether not extending the benefit of weightage marks to those outside the employment of the power utility companies would offend Article 14 and 16 of the Constitution. But then para 123(1), Millard, are examples of selective weightage, Millard. Yeah. But kindly permit me to come back on the next day, Millard.
Could you finish up with this judgment and
Well, I have to read, Millard,
more paragraphs?
at least 10 to 12 other more paragraphs. That's why I said, well, this is a digest. I'll keep it, Millard, for my future references.
All right. Ready? The learned AG commences argument but does not conclude the same. When would you like to come back?
But I can come back on Monday or next Tuesday also. Today we are on
10th.
Tuesday.
10th, next Tuesday.
Very good.
10 তারিখ।
Oh. 9th.
কি হয়েছে? ক্যান টুটা নেই।
Well, in this matter, I was added later on, and Lordships granted me to use an opposition also. So,
You want to file it?
it is identical. It is same thing, but still.
The opposition দিচ্ছে একটু দেখে নিন। Please file it.
Weekend একবার আসিস।
How many? How many? One means in volumes.
There are volumes of the SLPs and others. There's nothing new, and these are already.
Why add up documents which are not relevant or copies are there?
Because this is not going to.
And affidavit in opposition filed by, check up by who? And in 4 volumes. Please write that. No, you'll be getting all copies to be circulated.
You are the main person.
Certainly copy will be given.
Several affidavit filed by some of them get
You write letter so that the Did you serve the application? Not the opposition, the application you served.
I was already added as part.
The court added parties even though applications were not served with the direction to serve. And thereafter, these are not served. See, this is a submission that is being made.
Item number 21 can
না আমাদের কপি দিয়েছো ক্যান 5 বলছে অ্যালাউ হয়ে গেছে
Juniors.
If the opposition,
Oh, that's a different matter.
item 22, opposition, 21, 21, opposition filed by the which respondent? Clash applicant in can 5. It will be open for the petitioner to file reply if required. Otherwise, so many applications are there.
After filing all this, I will use a consolidated reply. Otherwise, it is very difficult to follow each and everyone's affidavit.
Anything else?
But we are yet to receive the copy of amended cost title after addition of parties.
The applicants are being added on daily basis. So we still do not have an amended cost title.
In process.
Uday Shankar Chattopadhyay, Suman Shankar Chattopadhyay, or Pranoy Basak over here? Any of them? No. Petitioner in Bhim Sarkar is you.
Fine.
Did these advocates file any application? Can 6?
Yes. The last occasion, Manoli, remember that
Huh. Withdraw করে-
last occasion, Mr. Budu Shankar Chatterjee will make submission thereafter. Probably memory
Disallow the cancel.
disallow. And I believe they preferred an
Appeal. আমাদের কাছে আচ্ছা Chattopadhyay, so that at 2 o'clock, right? This was mentioned. I do not know what is the reason.
mention.
It has been mentioned.
Correction.
এগুলো একটু ঠিক করে দিতে হবে। এটাকে রাখুন, দুটোর সময় আসবে তখন কথা বলে নেব। Item 19 is being heard, and with 2021 opposition file 22, 23, 24.
Up to 24.
Opposition filed in 19 also,
Yes.
and that opposition is for can number 3 added respondents.
লিখে নেবেন কিন্তু। All right. So we'll start from 25. তাই তো?
independent expert body. That is my stand before your lordship today. I would not ask your lordship and request your lordship to kindly verify which one is correct, which one is incorrect. For to that effect, my lord, we have prepared this compilation of judgment, which
Compilation of judgment.
because it shows. I will not take much time, only few paragraphs. This clearly says that the law has been given. What is the law today? My lord, need not to get into the issue. Only send it to the expert committee to decide whether I am correct or no. Why I make this submission? Rule 11. If your lordship kindly takes rule 11 for once. Rule
An
11.
expert has already checked the answer, isn't
After that, because why I tell you lordship, rule 11, there are 3 elements. First element is that I can raise objection besides suggestion. 2 words are used, suggestion stroke objection. So both have been used separately. When there is an objection, the requirement is that I have to give 2 authentic academic records with PDF. I do that. I pay money for that. So it's 100 rupees each question. Now, section 11 says that it is to be dealt by the expert committee. Now, my lord, when there is an objection, when rule 11 is asking for supporting material records, it is duty incumbent, the statutory duty upon the
Where
expert.
is the requirement of production of 2 support
Yes, kindly take rule 11.
study materials and
Take
something?
rule 11. Rule 11 of the recruitment rules. Kindly take 11.5, Roman 5. May place before lordship. Roman 5, the Central Commission shall publish in its official website preliminary model answer keys after the written test and may invite suggestions and or objections from the applicants. Provided that suggestions or objections must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. Next, the Central Commission shall form a subject-wise expert committee comprising not less than 2 members in the rank, not lower than professor of college, university. The expert committee shall deal with suggestions, objections. Now, my lord, there are 3 elements. My respect.
Show me their
yes.
report.
Yes. Kindly take their report. Page, the last page, page 10, the annexure. I have objection regarding 2 questions. I am short of 1 mark to qualify. My lord, kindly take this first 1 to 22 answers are unchanged with original master key. I have no objection. I do not fall within 1 to 22. 23 question itself is wrong and out of syllabus. They give a reason for change. They give a reason. I don't fall.
Which one?
Next
which
one is
question?
mine. Mine is 27 and 42. So I come under 24 to 47. They say answer are unchanged with original master key. No reason assigned. Merely saying answer is unchanged. My respectful submission before your lordship today is when you are changing, you are giving reasons. When you are not changing, you are simply saying that it is unchanged. You are not considering 2 academic records. You are not dealing with what the statutory interpretation of dealing with is that you have to exercise your mind. You have to say why 2 authentic academic records I am relying is not correct. You have to come up with that. Now, my lord, I have one more submission, my lord. I will not take much time of it. From this report, I can show. Your lordship, kindly take page 6 of the report. Page 6, kindly take. Page 6, your lordship has seen. This is the grievance details. Kindly take 27, which is my question, master key wise. Your lordship will find 2,928 objections were raised against one single question. So I do not come as a stray person with one objection that is not correct. 2,928. Everybody has given their objections with supporting materials. Now, my lord, kindly see.
And what is your submission that the question is wrong or out of syllabus?
My submission is this. The question number 1 is
27.
Yes, 27. My question is correct answer will be D and not C.
That means the change in the.
No. Now there is one difference here. They say they accept question is wrong or out of syllabus. There are 6 grounds under which the wrong can be considered. I will show that. So they do not go by my challenge. There is no consideration of my challenge that you have to take D, not C. They say question is wrong or out of syllabus. Why? They have given the reason in the report. The majority of objections say the question is wrong or out of syllabus. But in the rule, it has never stated that you have to take the majority objections.
No, that is how can you take that?
They,
Alright,
they
that's
cannot.
alright.
Yes. Now, my lord, kindly take 42. That is also my question. 42, my lord, your lordship will find 975 objections. And the nature is question is wrong or out of syllabus. But I had stated that the question, the manner it has been printed, it is Sanskrit. It's a very technical subject. The manner it has been printed, merely there is a gap between two words, the meaning gets changed.
All right.
And the answer also accordingly changes, which I can show from my writ petition how I have explained it. My learned friend has taken a point that I have changed my objection in the writ petition, saying that petitioner suggested that the question is wrong or out of syllabus, and objection has been changed in writ petitioner, says that the correct answer will be C and A. Because I could not say this in the objection because there is no such scope for writing. It is preset objections in the drop down box. In 6 counts I cannot say that, see, the word is wrongly printed in your question paper. I cannot say. So I had to click in the nearest objection I could get. Now, my lord, kindly take page number 8. So my objection is also not there, has been considered. They have taken the majority, which is not there. Now, kindly page 8, these are the 6 grounds. So they are duty bound to consider my objection under these 6 counts. But my objection has not fallen within this. They have not dealt it in this, have not. Now, my lord, so far the law is concerned, it is very specific. My lord, I have found absolutely similar and identical issues. Same expert committee was appointed. There was a provision for objection. The court has category, very recent judgments of Rajasthan High Court and Madras High Court. They have said that no, when you have come up with substantive material records, it has to be checked by the independent body. Now, my lord, Honorable Supreme Court has categorically stated that when there is such objection raised, it is the duty incumbent. Yes, I admit to the extent, my lord, the Honorable Writ Court is not a fact-finding body. Honorable Writ Court is not the expert body. Honorable Writ Court will not sit over the appeal of the expert committee. I admit and concede to that. I will not make one objection to that. But when I am able to show from material records that my answer is also correct, it is the duty incumbent upon to be sent before the commission.
All right, let me hear once. Commission. Is anybody online? No? All right.
Yesterday, similar matters were adjourned, citing pendency of MAT
30.
30.
MAT 30 is my matter. Questions are different. Not all issues are same. Over there were 2 different questions.
That matter.
Yes, it's my matter only.
We have produced the compilations also of judgments.
All right.
In fact, if that issue will not, let us understand it very clearly, subject to what falls from your lordship. If your lordship is persuaded to hold that yes, the court may direct this, that issue is your lordship rejected the prayer.
Please hear what the court has to say, then you make submission.
And that matter, my lord, it is different. There are 2 separate questions because.
All right, wait.
And there is no stay of your lordship's order.
The report that you filed, the chart, it is not paginated, right? After page 5, so it will be page 6.
I have paginated this one.
20 doesn't matter. 27 question number. How have you dealt with? 27 and 42.
42. Master key number.
How have you dealt with? You have merely said that the answers are unchanged with original master key, right? Now the rules have been placed which mentions that you are to deal with it. Does the word deal mean only giving one line, that the answer remains unchanged when the candidate has supplied 2 authenticated academic publications?
Authenticated,
this is your language. The court has not used it. Now, if you say that no, it is not authenticated, it can be. I do not accept it because it is not authenticated. It can be a mode of dealing it. But how have you dealt with? It's very mechanical.
I don't think, I do not know, I may be incorrect. This report of the SSC perhaps has not been dealt with by my learned friend.
Yes, an exception has been filed today.
Given to Mr. Singh. I can give you a copy also.
It has been filed.
Exception আজকে দিয়েছিল।
আজকে না, অনেকদিন আগে দিয়েছি। That is the standing instruction that I have to send to Mr. Singh.
নিশ্চয়ই আমরা পাইনি।
I have dealt with.
হ্যাঁ।
That is just one reference, Mano. That is the authentic copy. That is the ISBN, ISSN number books and text materials. Instead of authenticated, authentic books.
Whatever.
Yes.
How have you dealt with?
Whatever is there in the report, I cannot improve on anything beyond this. In the other matter, the commission has been directed to use an affidavit now. If your lordship wants us to file a detailed affidavit, we can file a detailed affidavit. Pardon me for saying this. Yesterday also I made this submission. What the Supreme Court is saying, this domain has to be left on the experts. One.
Do it, but let the expert act in accordance with the act and the rules.
Now,
more than this.
Provided there is a contemporaneous finding that the expert has refrained from doing so.
The expert, you see, what will you say? The answer remains unchanged. The law requires that the decision of the expert committee shall deal with the suggestions, objections. How has it been dealt with? Apropos the objection made, how has the expert committee dealt with the objection? Nothing more.
Then we'll use an affidavit.
My lord, there is no scope for development in this matter. I don't know what.
Let the matter be argued, my lord. I believe, my lord, let my learned friend.
Learned friend has submitted. There is nothing to develop.
My lord, let us, my lord, argue it once for all. Let it be decided.
Exception.
The matter is pending, my lord, consideration in the honorable division bench.
There is nothing to develop.
No, exception to the
Then again, affidavit.
petitioner. To the except by the petitioner to the report by the commission.
মামলা অ্যাডজান্ট হচ্ছিল তখন তোমার গ্রাউন্ডে ছিলে, তোমার গ্রাউন্ডেই তো অ্যাডজান্ট হচ্ছিল।
If they can't make submission, I can't take the responsibility.
That doesn't prove that you can make submission.
Learned advocate for the petitioner.
আমরা তো কি জানি না, কিন্তু এটা তো ঠিক না।
Within brackets,
there is nothing new to submit.
Small v.
You cannot develop. Then what is
and
the evidence to
6
be developed?
PI of the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes. এটা এখান থেকে কপি করবেন, হ্যাঁ। Third bracket, except work education and physical education, bracket close, comma.
My lord is quoting a rule, my lord, on the basis of which no examination has taken place.
9 and 10. And classes 11 and 12. Comma rules 2025. Stop. The wherein, comma the wherein there is a wherein the central committee is required to publish in its official website preliminary model answer keys after the written test and may invite suggestions and / objections from the applicants. Stop. The suggestions / objections are to be submitted within 5 days after publication of such model answer keys, supported by at least 2 authentic academic publications. Stop. The petitioner objected to TWO2. প্রথমে TO, তারপর TWO. Two questions. Stop. The expert committee dealt with the suggestions/objections. No, dealt with no. The expert committee opined that the answers to the subject questions remain unchanged with the original master key. Stop paragraph. Submission of the petitioner is that the expert committee ought to deal with the suggestion/objections and not merely make a remark that the answer remains unchanged. Stop. Paragraph. The order decision making processটাকে আমাকে show করতে বলা হয়েছিল, that is not given in the report. The full discussion is not. It's been a full elaborate discussion after which it has been arrived at. This decision has been arrived. Learned advocate representing the commission submits that the expert committee considered the objection filed by the petitioner and accepted some of them.
It is deemed.
The recommendation of the expert committee is final and binding in terms of Rule 11 within bracket VI. Stop. The petitioner is trying to re-evaluate the answer script, which is impermissible. Stop. Next. From the report filed by the commission, it is not very clear as to how the academic publications relied upon by the petitioner as to whether the academic publications filed by the petitioner were considered or not. Stop. The mode of consideration of the academic publications relied upon by the petitioners shall be placed by the commission before the court by way of an affidavit.
No, my lord, after your lordship complete the order, my lord, will indicate something, my lord. It is a part of the report already.
Show me.
Yes. Please. No, please come to the. My lord, kindly comes. Kindly takes the report. my lord, this is how we have dealt with it. My lord, kindly comes to paragraph 3 onwards.
I have checked up paragraph 3 onwards.
Yes.
You have not mentioned anything about the publications.
My lord, about the, my lord, there are, my lord, on any given subject, there might be 10.
Maybe 20 also. How does it matter?
That is, my lord,
He
experts
has
will not
relied
consider.
upon 2 because your rule requires 2.
My lord, experts will not particularly give emphasis on a particular book.
Rule.
My lord, kindly seize the rule. Rule to the- My lord, kindly seize. My lord, please see, my lord, I read, my lord, in my own subject. It is stated that my lord, paragraph
Which
8,
one?
paragraph 4
From the report,
of the report.
you show me from the rule how the expert dealt with the academic publications, nothing more.
My lord, paragraph 5, we have stated.
Yes.
As per Rule 11.6, the Commission invited experts in the field of Sanskrit to form an expert committee. The expert committee was headed by a professor in the Department of Sanskrit. The experts invited were kind enough to accept such invitations, and the expert met on this. The Commission provided the compilation of grievances and objections received by all the applicants, syllabus of Sanskrit, question paper, and the preliminary answer key to the experts for their review of the preliminary answer key of the Sanskrit PG and for dealing with the objections raised to 50 questions by different candidates, including the petitioners herein, the identities of the expert, etc. Then,
Nothing is mentioned.
then, the expert committee met on this and they deliberated upon the various objections, including upon a detailed, the expert committee found objections with respect to 4 questions to be valid and suggested appropriate changes. In fact, the expert committee found one of the objections made by the petitioner in respect of question number 36, series C, corresponding to question number 60 of master code to be correct and as suggested by the and suggested appropriate changes. All the changes suggested by the expert committee were duly incorporated by the commission in the final answer key. The signature of the expert have been marked, and then we have annexed it is at annexure C.
This is the last one page handwritten which you have relied upon in respect of all the objections.
This
that
is
have come.
yes.
How the experts have dealt with the academic publications.
My lord, kindly come to page 8 for once. My lord, kindly take page 8 for once. I can show one thing in respect of paragraph 5. Kindly see. My learned page 8. Kindly see. My learned
page 8, the handwritten portion.
No. I am showing. My learned friend has submitted page paragraph 5, where the annexure is paragraph B. So he's relying upon paragraph B, and according to my learned friend, they have considered the objections. Now kindly take page 8. 8 at the very bottom. What are the documents placed before the expert committee? The question booklet, the preliminary answer key, and the syllabus are being attached with this mail for your kind perusal and preparation in advance. There is no whisper of the records. Yes, it is not correct. With deepest respect.
This is the final recommendation of the expert. Certain things are beyond the purview of even the writ petitioner. It is not his domain as to how the experts have come to a particular conclusion.
Sir, just tell me how the expert.
If your lordship, this is something very internal. What weighed with the experts, how they have considered it.
Did the expert consider it?
Yes.
Show me.
That we can. If
you mention anything over here.
This is the final recommendation. Again, I am saying.
No, the report.
This is the final thing. What your lordship is looking at page, whatever this page is, page 10, this handwritten portion is the final recommendation. Deliberation.
We can produce it before the court.
That will be we'll be producing it in a sealed cover for your lordship.
What sealed cover?
That cannot be that weightage. This is beyond he is inviting your lordship to travel.
No. The petitioner has relied upon certain books. You say it is not authentic.
I am not saying anything. The
expert.
Is
the expert.
They have considered it.
Yes, the expert will say, no, this is incorrect. This is not authentic. Let them say something that yes, this study material was considered. The court will end over there. The court will not traverse beyond that. কি বললাম?
There is no consideration. They have to say why those documents are not correct even.
আচ্ছা বলতে দে, বলুন ঠিক বলুন গচ্ছা বলছেন আমরা করে দেবো।
Read book B, students 3 will read book C. Just সব বই কনসিডার করতে হবে নাকি?
By
Everybody is reading different books. There are hundreds and thousands of books.
There were 2928 objections. Milord, if 2928% suggest books, then Milord,
why did you frame? Why was such a rule framed? There was no requirement of submitting objections with
Milord, to
authentic
become more
more transparent.
we have in fact
There are
to
5,
his one
6
of his
books.
questions. He is not saying that.
There are 5, 6 books.
He is not saying that.
I have recorded in the order. He is not saying I saw your affidavit and I recorded that you have corrected one of the
Take me.
answers.
The domain that your lordship is being invited to travel to, Milord, is perhaps beyond the scope of a writ petition. Milord, kindly pardon us.
Acha.
There are 5, 6 books, ISSBN number, we have followed that. Everywhere same answer is given.
24th of February. Released 10th of March.
10th of March.
My lord, my
In the meantime, check up what happens to the appeal.
yes, my lord, my interest will be protected in case I come successful, my lord.
Obviously, it goes without saying, it is recorded the candidature of the petitioner shall abide by the
Irrespective of this, if he
result of
gets a chance, he gets a chance.
He gets
Will he
a
wait for
chance.
the outcome of the writ petition? I don't think so.
Obviously not.
Of course, I'm
No,
1 mark short.
He has not reached the cutoff only.
1 mark short I am only.
There are so many
Yes,
candidates.
yes. And my lord,
Mixed bag,
so far the
compilation
book,
লাগবে না।
next occasion I will be submitting. My lord, so far the books are concerned, it is the ISSBN number. These books are taught in the classes, which I have relied upon. They cannot say this book is wrong. They have to come up that I'm not accepting this book. They have to come up with that. 26 also similar, my lord. It is subject nutrition. একটা second. ভুলিয়ে গেছে।
How many questions?
6 questions. এর স্বরূপের ভেতরে ঢোকাও। পরেরটা ঢোকাও। This is my exception to the report. এই হার্ড কপি দেবো বিশুদ্ধা হার্ড কপি দেবো এটা দেখে নাও হার্ড কপি
Scan করে ঢুকিয়ে দিবি।
Which question?
Yes, my lord, kindly take questions number 2. Your lordship is referring to the page, it is not paginated. The question number 2, master key 2, 13, 17, 40, 42, 52. It is in the first annexure of the report given by the commission, and your lordship will find in similar manner it has been dealt with.
How many questions have you objected? 6 questions.
Kindly see the objection. Kindly take the first. In question number 2, 571 objections. In question number 13, 134 objections. 17, 115 objections. 48, 67 objections. 42, 275, 52, 839 objections.
48, question 48.
No, question 42.
42,
13, 17, 40, 42, 52.
2,
13,
13,
17,
17,
40,
40,
42,
yes.
52. These are the master key numbers I'm giving. Now, my lord,
And you did not object to 18.
lordship.
1923 objections.
Yes, kindly see. No, I did not. I do not.
You did not object.
I did not object to that.
All right.
My lord, kindly come to the last annexure.
Yes.
Your lordship, this is even worse.
3,
2 is not there.
3,
2 is not there, my lord. 2 I objected is not there. 13 is not there. 17 is not there. 40, 42, 42 is only there. 40 is also not there. 42 they say the question is not properly.
কি মুখ বের হোসেন হচ্ছে?
no.
Option A may also be correct.
Option A may also be considered in addition to option B.
Option B. So they are not even sure what should be the answer. Now, my lord, 42 is there, 40 is also not there, 52 is also not there. Kindly take the last line. The answer for rest of the questions which were
Referred to remains unchanged.
There has to be a reason why it is unchanged. Why you are not considering these academic materials? So many objections. Not I have come up with the objections. He has to come up with the same logic I'm relying upon.
কোয়েশ্চেন নাম্বারস গুলো কি আগেরটাতে বলেছিলাম?
চেক ইট পড়ে কি 34 35
বলিনি না? এখানে লিখুন ওই কি দিয়ে শুরু করেছিলাম ওখানে? হ্যাঁ, এক্সেপশনটা টেকেন অন রেকর্ড। তারপর হচ্ছে
সেটা দেখতে হবে স্বরূপ চক্রবর্তী কিন্তু
Here your lordship is looking at a petition of 24 petitioners. There is also one 24 petitioners. This it is very extremely difficult. Yesterday I objected, to one of the writ petitions.
and
98.
possibly all the petitioners
They did not object to single questions.
produce similar study material.
Similar study material, those
All same study material.
Not all 24 have been agreed by 6 questions. My lord, they have given the study material. These are
out of
these are all common study materials which are studied by all the candidates. These are available books. All IS.
Let them file 24 petitions.
Maybe some candidate whose answers were found to be correct read other books, or
no, these are similar in all books. My lord, suppose the question is very simple.
Out of 24 petitioners, 20 have raised objection.
No.
Out of 24 petitioners, 20 have made objections for different questions. And my lord, what I find from records that my lord, against my lord, one question there were 12 petitioners, against one question there were 19 petitioners. And my lord, every document, every issue cannot be the same.
But if the marks
So my lord, there is, my lord, as I was submitting before your lordship yesterday, there is no homogeneity. It cannot be a, my lord,
who are the candidates who did not file any objection at all?
My lord, it just gives me.
Writ petition shall be dismissed in respect of them.
Kindly appreciates, my lord. If the question is correct, my lord, kindly do not deprive them of their marks.
If the question is correct and if answer is given, then he will also get marks.
Yes, so kindly do not dismiss them, my lord, at
No,
this
what
stage.
to do?
No, and not at this stage, my lord. Not at this stage. If your lordship finally holds it, very well, no problem. Not at this stage. Let it be decided, my lord.
First, you tell me, without raising an objection, how can the writ petition be filed?
No, possibly all of them have.
He has used the report, but in paragraph 2 of our report, we have indicated that. Paragraph 2.
The numbers.
Paragraph 2.
This is the exception.
Yes, this is, please see his exception. They have raised questions against 6 questions before this honorable court, but at the preliminary stage, all the petitioners raised different objections. In fact, out of 24 petitioners who have approached this court, only 19 raised objections in terms of Rule 11(5). The remaining 5 petitioners have no right to institute the writ petition by piggybacking on the 19 others.
You write on the others. Rely upon
Not
the
my
others.
language, Miller.
I did not know
Whoever.
what is piggybacking. I did not.
Yes. How will the 5 maintain the writ petition?
Yes, my lord. Yeah. My lord, if ultimately it is found the questions are my contentions are correct, my lord, let them not be deprived of the benefit, because if it is wrong for all, right for all.
Right. So if it is found to be right, your objection in respect of
19.
the benefit will go to the rest also. It is not that it will be restricted only to
Those who have
you.
come before the court, those who have accepted it, they have chosen not to come before the court. They are not interested to get the marks. I am interested, my lord. I have come. I have lost this battle, my lord. That is why I have come. They are not interested.
No, but then the law requires
that is
to apply within a particular
that
time.
is a procedural mechanism, my lord. Kindly appreciate that.
All right, I'll take care of.
Yes,
The rest can be deleted
that-
or dismissed or whatever. But
Not
then how has the study materials been considered? The court wants to know this only. Otherwise, nothing. And moreover, see page 11, whether